Good evening, Crime Talk aficionados. My name is Scott Reisch, and this is Crime Talk. It is Tuesday, so we are doing our Tuesday night live show here for you. Thanks for joining us. Now, remember, you know the drill. Subscribe if you haven't. Like if you do. Leave me a comment below. Hit that little bell for notifications. And yes, you can listen to us anytime on any of your favorite podcasting apps. All right. There's that little standard introduction. We got to do that. Now, let's hope everybody had a wonderful Labor Day weekend. I don't know about you, but I needed that quick little break. I don't know why. Yes, you can say, well, Scott, didn't you just go on vacation to Sweden? Well, yes, we did, but it was so jam-packed. The schedule was so tight. Everything was scheduled, so to speak, very little downtime at all, not to mention the time change, and then just came back, and it was nonstop. And, oh, yeah, we, of course, had a homicide trial 2 weeks ago now, 3 weeks ago, I guess. It seems like forever ago. That didn't go well. So I don't know. I was just tired. I needed a little break. And so the lovely Miss Kristen and I broke out of town, went down to my adopted home state of South Carolina, went down to the Low Country in South Carolina, where I just love it. It's beautiful. It's gorgeous. The people are so lovely. There's just something about, being down in the Low Country, Beaufort, Hilton Head. It's amazing. Okay. The Bluffton area. We ate at this restaurant. I hate to give away this restaurant, but I'm telling you, if you were ever in the Hilton Head area, just before you get to the island, there's a little area, Bluffton. It's expanded. I wish I'd bought there 30 years ago. But there is this restaurant there called Farm. We ate there last time. We were there last year. I think it was last Labor Day as well. It was amazing. I mean, it's this little restaurant. We had to get in 5:15, the old people special, so to speak. And, oh, my God, it was just to die for. I love that place. This service is amazing. This is not a paid endorsement, okay? It was just amazing. So, remember that if you're ever in the Bluffton, South Carolina area, go to Farm. It's farm to table. Everything was so fresh. It's like little explosions of flavor just going off in your mouth every time you took a bite. The service was incredible. The food came out quickly. I mean, it was just, I love this. I love it. Anyway, got to start something personal about being near the water. The first day, it rained all day, pretty hard all day, but that's okay. We had to do work that day. I was down there checking out a property that I've had forever that's currently being rented, had a couple of issues. So we had to make sure that was taken care of, but then we got to enjoy one really great day. And then the other day was partly cloudy, but it was amazing. So remember, South Carolina, you'll hate it. Don't go there. Okay. I'm telling you, it's terrible. And then you got Savannah down there. Went to a cigar store right before dinner. We were I was partaking of a fine cigar. Met a nice young kid, works for Gulfstream. He's not an A&P mechanic yet, but he says they pay really well, as much overtime as you want. And he and his young bride or bride-to-be moved from California for that opportunity. And they just talked about the opportunity that they felt by moving down there to the East Coast. And specifically, they lived in Savannah, but they were up in South Carolina, enjoying a fine cigar as well. At least the young gentleman was. So, once again, Gulfstream, hey, if you need a lawyer, you need a pilot, I am your guy. Just putting that word out there for you. All right. Enough of that nonsense. That was my weekend, but I hope your Labor Day weekend was just as good. I'm telling you, everybody needs a little break. I remember when I first started my practice years ago, I think I took one vacation like in the first 7 years. And now, I don't know why, but it seems like those little vacations, the little recharge the batteries, need to take place about once a month, at least a long weekend. I don't need a long vacation, but I need a couple of days of relaxing, of completely mind numbing activity that takes my mind off of work, which is still hard to do, but that's all we want to do. Another thing, ladies and gentlemen, if you haven't done so already, maybe you should think about it. Come to Denver this week, Thursday. Well, I think Friday is officially the day CrimeCon starts. We've been to it in the past. We went to it in Las Vegas. I think we missed a year. Then we went last year. We didn't present anything out in Nashville last year. But obviously this year we're going to have a little booth. And if everything goes well, our little giveaway that we're giving away, hopefully it'll all arrive. It's been ordered. The order's been placed. They say it's being shipped, but I hope it gets here by Friday. That is the goal. Otherwise, we're going to have not anything to give away. I guess we could go around the office and start bringing things like who wants a Magic 8-Ball? Who would like a mug? Something along those lines. It won't be a whole lot, but we have a lot of our giveaway. And obviously, it's a giveaway, but one little thing. You have to be a subscriber. If you haven't subscribed, you got to subscribe, on YouTube. And then we'll give you a cool little giveaway. And we'll have a little thing set up. We got this cool thing that we did years ago. We're going to totally recycle it. And, if you'd like to have your picture taken or meet us, we're going to be there. Won't be there the entire time, day and night that it's there. But I plan to be there most of the time. And I believe the lovely Miss Kristen will be joining us. Obviously, Frank, the hardest working man in show business, will be there. And maybe even Miss Winnie the Bulldog will arrive. So we'll see how that goes. All right. But let's get to what I wanted to talk about tonight. All right. Barry Morphew. All right. Let's have a show of hands. How many people are familiar with the Barry Morphew case? Okay. Yep. I see it. A lot of people are familiar with the Barry Morphew case. At least they've heard about it. Obviously, Barry Morphew is charged with the death of his wife, Suzanne Morphew, who disappeared back in May of 2020. And we can go through the timeline of events, but let's just say the first trial didn't go so well for the prosecution. Let's just say the prosecution screwed it up every which way you possibly could. And the district attorney at the time, Linda Stanley, got disbarred. That's how bad she screwed it up, ladies and gentlemen. She screwed it up so bad. It deserved to basically have the case dismissed. The case was filed prematurely. The lead detective at the time said the case wasn't ready for filing, but Linda Stanley was looking for headlines. She was trying to make a name for herself, bringing justice for Suzanne. And everybody wants justice for Suzanne Morphew, right? Who wouldn't want justice for Suzanne Morphew? Obviously, the big question is, did they get the right guy? Remember, first trial, no body. The old no face, no case makes it a little more difficult to prove that somebody's dead when you don't have a body. Not necessary in every case, but most prosecutors don't like to do that unless they actually have a body or can explain why there is no body. Something to think about there, ladies and gentlemen. That's just the way it is. Prosecutors like an easy case. They want to win. They're supposed to win. And they like it when when it really favors them and they have all the good facts in their favor. So remember that as well. All right. So anyway, prosecution totally screwed up the case. It wasn't ready to be filed. She was looking for headlines. Discovery problems throughout, right? Everybody knows everything the prosecution has to turn over to the defense. The defense doesn't have to turn everything they have over unless they intend to use in their case in chief, but the prosecution has a duty under Brady v. Maryland to turn over all the discovery, and particularly exculpatory discovery. And they had some issues about, some potential DNA that was in the glove box of the car, some weird things that went on, and the prosecution didn't have time to explain it or fix that, because they were too busy dealing with the voluminous discovery that normally small town jurisdictions are not used to when it comes to big cases like the Barry Morphew case that gained, not only public attention here in the state of Colorado, but nationwide as well. So needless to say, make a long story short, judge basically guts the prosecution's case. They dismiss the case. Okay. And I hate when they say without prejudice, because there is no such thing without prejudice in the sense, as long as the statute of limitations hasn't run, which there is no statute of limitations for murder, they could just say, Judge, we're going to dismiss. They don't have to give any reasons why. And as long as, the prosecution has some new evidence or something to that effect, it's totally legit. They can do that as long as they do it before they see the jury. And it better be some new evidence that came forward. Well, guess what? The prosecution got that. They find the remains of Suzanne Morphew in Saguache County, kind of down there by Alamosa, where the trial is here, and in Chaffee County, where the Morphews lived at that particular time, near anywhere close to in that area around Salida, Colorado. Okay, so they find her remains, they do an autopsy, and they say, hey, guess what? We have evidence based upon our forensic people, our toxicologists, that are going to say that there is this particular tranquilizer, and I'm not going to go through butchering the names of it right now, but it's called BAM is the acronym for it. And basically it's a tranquilizer for animals. And now guess what? The coincidence, right? What do we say? There are no coincidences in criminal law. There's no coincidence in politics and crime. Just remember that, ladies and gentlemen. Anyway, what does it turn out to be? Barry Morphew, coincidentally, just happens to be the only guy within the area other than, state forestry guys or divisions of wildlife personnel that have access to this particular tranquilizer. Now, remember, the tranquilizer stuff came up early on when officers found these tranquilizer caps or something to that effect in the washing machine when the case was originally going on. But that's kind of the new evidence. Anyway, Barry Morphew gets arrested, or Lee, as he likes to go by now, apparently. And we'll talk about that a little bit more in a second. He gets arrested, gets extradited back to Colorado, waives extradition, comes back. Judge, at his initial appearance, says, I'm going to set the bond at $3 million cash only, right? Seems reasonable enough. You're charged with a class 1 felony that carries the possibility of life without the possibility of parole. You don't really have ties to the state of Colorado much anymore, right? Your daughters have left, you've departed off to Arizona, where you go by Lee and engaging in some, real estate investments, something to that effect. All right. So Barry Morphew appears back in court for the initial appearance, initial advisement, what they call Rule 5 advisement, make sure he understands his rights. The defense attorneys, not the same defense attorneys that they had last time. As remember, last time Barry Morphew had hired Iris Itan and Drew Nielsen to handle the case. That firm is no longer together. They've split. They've each gone their separate ways, but very fine attorneys all around. Then this particular time, Barry Morphew hires from Dan Reisch's office. God, why is his name escape me? And some other lady that I saw just the other day. Hold on, his name will come to me. Anyway, they file a motion for a new to address bond. And of course, the judge says, yeah, right, we're going to kind of, redact some of that motion as it relates to the Barry Morphew matters, because there's some stuff that's privacy and we want to, kind of limit that production. Okay. That was an order dated August 29th. Pursuant to Rule of Criminal Procedure 55.1A2 and 6 through 8, the Morphew motion to limit public access to his motion to reduce bond, defense motion 7, is granted. Permitting public access to Mr. Morphew's motion by releasing only a redacted copy serves the substantial interest of protecting the identity and thereby the security of individuals identified in the motion to reduce bond who are not Mr. Morphew, as well as other information contained in the motion that would not otherwise be public under privacy-related rules. The substantial interest to redact a minimal amount of information in Mr. Morphew's motions override the presumption of public access. So there you go, right? That's what they're going to do for that. Now, Barry Morphew appeared in court today. He was in civilian attire. I mentioned in the show that we talked about today that that's kind of an interesting thing, because in the surrounding jurisdictions, that just never happens. The sheriff's deputies, they don't have time to deal with that. Nobody cares how somebody comes to court. I mean, hell, you should see most of the people that come to court, that have court, that are out of custody, usually they look like they're changing the oil on your car. Judges are actually impressed if you dressed for it, but no one's going to hold it against you, particularly for the fact that you're in custody, right? So anyway, the motion to reduce bond, the redacted version, basically is saying that, hey, that he's in custody, and you got to look at the statutory considerations when it comes to bonds, which is basically danger to the community and are you a flight risk? Those are the two biggest things. Now, says, Colorado statutes compel the court to presume that Mr. Morphew is eligible for relief on bond with appropriate and least restrictive conditions. Consistent with these conditions are no stricter than required to reasonably ensure the appearance of the person as required and to protect the safety of any person or the community, taking into consideration the individual characteristics of the person in custody. So they got to look at the employment status, the nature of the offense and his family relationships, past and present residence, character, reputation, the likely sentence, consider the nature of the offense, his prior criminal history. And so what do they go through? They go through all the facts. Employment. Mr. Morphew has always been gainfully employed as an expert landscaper. Bunch of redactions. By this arrest in this case, he has had numerous business contracts that will provide work for him. Family. He also has an aging mother, because there's a bunch of redactions there. His family remains extremely close and supportive of Mr. Morphew. Residence. As stated above, Mr. Morphew has his own residence, left blank. Otherwise, he will reside with or at another location if ordered by this court. Mr. Morphew has many close contacts in blank, many of whom have offered to place him to stay should the court reduce his bond to a reasonable amount. Character. Prior to the government attempt to portray him as a criminal, Mr. Morphew's reputation was excellent. He is an honest person who is genuinely eager to clear his name so that his former fine reputation can be restored. Persons will assist him in pairing Mr. Morphew's legal teams. Friends and daughters will provide all needed assistance to ensure all court appearances. Mr. Morphew is innocent, and there will be no sentence imposed. If hypothetically he were convicted, the sentence would depend upon the degree of offense and could range anywhere from probation to a mandatory life imprisonment without the possibility of parole. It must be noted that these were the same sentences he faced previously. Criminal record. Mr. Only conviction is his guilty plea to a Class 5 felony forgery of a government document. He satisfactorily completed a 1-year term of probation. It should be noted that he was blank while he was on probation. He always appeared or was required, has never had any issues with compliance issues. Possible violations of the law or intimidating witnesses. Mr. Morphew has not committed any violations of the law. And guess what? He will not harass, intimidate, violate anybody's, any witness in this particular case. Then they go through a bunch of the legal standards. Find a probable cause does not disturb the innocence presumption and is not a substitute for showing that would justify severe pretrial restrictions on one's liberty. And so there we go by, obviously cruel and unusual. And I'm sorry, it was David Beller. I had a brain freeze there. David Beller is his new attorney, along with Jane Fisher Bryaslison. Now, I know who David Beller is. I don't know. I probably chatted with him 6 months ago on a particular matter. But I also remember him when he was a young public defender in Adams County. Knew the guy. You could just tell the guy was going places, very confident, always prepared, showed up for court, ready to go. I have nothing bad to say about any of the attorneys in this particular case. So that was the motion. So what ultimately happened? Now, remember, the defense wanted to reduce the bond to the $500,000 that was previously imposed the last time that Barry Morphew had to go through this whole process where the case was ultimately dismissed, which he posted the bond, $500,000 cash. And that's what they wanted, because right now it's $3 million in cash. That's a lot of money. I don't know about you, but could you go write a $3 million check, certified funds, to get somebody out of jail? Probably not, right? What's the legal standard? Are you a danger to the community? Are you a flight risk? But the bond should be no greater than reasonably necessary to assure one's appearance in court, and no greater reasonably necessary to restrain one's liberty to make sure that he appears in court. All right. So that's where that stands. So what happened today? Obviously, the prosecution objected to it. They thought that, hey, judge, there's nothing new here, but we know that, guess what? We have better evidence this time, and we want that $3 million bond to remain in place. All right. So let's face it, he's not getting a PR bond. No PR bond for Barry. All right. So what did the court do? All right. So you have a couple types of bonds, just to give you this perspective. It's pretty much the same in both states. But let me tell you how Colorado works, because that's what we're dealing with Barry Morphew. All right. Obviously, he's not going to get a PR bond, because given the nature of the offense, it's just not going to happen, ladies and gentlemen. That would be a personal recognizance bond. You simply promise to appear and you show up, and people fail to appear on all those. And I can assure you the amount of money recovered from somebody on a personal recognizance bond, if you were to go do an audit of those books with the state of Colorado, would be zero. Okay. The state doesn't collect on any of them. So if the court says you're failed to appear on a $10,000 personal recognizance bond and you don't show up, you're supposed to technically owe the $10,000. Not a single penny has ever been collected since the bail reform stuff that went into place during the COVID era there. All right. Just keep that in mind. So then what do? You got a cash bond, right? That's what Barry Morphew was originally given. A cash bond. Post $3 million cash. The state will hold it, in their trust account. And when the case is over, they'll give it back. Okay. Assuming he shows up for all court. If he fails to show up for court, that money then becomes the product of the state. It's theirs for the forfeiture. Fail to appear, they take the money. That's the one way to do it. Cash. You can do property in Colorado. So the bond is $3 million. Usually on a property bond, you have to be able to show the assessed value is $3 million or more, not just like, oh, here's my retail listing from my realtor who says it's worth $3 million. Assessed value is usually what it is. And it usually, they require it to be 1.5 times the assessed value. So 1.5 times of 3, we're talking, you have $4.5 million in property. I somehow think that's not going to be an option. The next option and the last option is bail bondsman. All right. Now, bail bondsman used to be so prevalent in this state. Everybody got bonded out. It was great. When I first got out of the military, opened my practice, I went down to Bondsman Row and I said, hey, man, I'm just starting out. Can I give you some cards, in case somebody needs an attorney? I'd really appreciate it. And there was this old retired guy. He goes, what branch are you in? All right. We sit, we chat. And he says, give me a bunch of your cards. And I'm like, okay. Didn't think anything would come from it. And, next thing you know, I start getting phone calls on Saturday and Sunday. And this bondsman, great guy, would be literally like, hey, I got a client for you. Hold on. And he'd hand the phone and say, hey, here you got in trouble, blah, blah, blah. And let's set an appointment to meet. And it was great. It was great. So I got my practice started, in all honesty. So bondsman. Then bondsman kind of fell in, what's the word I'm looking for? I don't know. What's the word I'm looking for? Bondsmen were not held in the highest regard. All right. Even though they were licensed professionals in the state of Colorado, let's face it, just about every scumbag in the world could become a bail bondsman at that particular time. And there were good and bads with bail bondsmen. I mean, you had clients that had bail bondsmen. You had attorneys that knew bail bondsmen, right? You could help a bail bondsman out. He would, maybe throw you a couple of cases every now and then. And then when he had somebody not show up, you did the work for the surety to make sure they didn't have to actually pay, got a little more time for them. It's just the way it is. But like I said, some of them are absolute scumbags. Somebody comes in just for easy numbers, a $10,000 bond. They pay the guy $1,000, show up. Maybe the guy doesn't pay everything or doesn't, have enough collateral. Then, they would revoke the bond. And sometimes after like 10 days, when the surety had actually earned their money, right? Not that they got to keep it all. Let's just say, for example, it's a $10,000 bond. They pay the bail bondsman $10,000. Bail bondsman takes with this little piece of paper that says, hey, I'm good for it through this insurance company. If he doesn't show up, I'll pay the $10,000. And so after 10 days, they've earned their money, but they didn't get all of that $1,000. They had to put some in what they call the buff fund, which is where they would kind of a little slush account, so to speak, so that if they did get put on the board for writing a bad bond and they hadn't brought the person to justice, brought him back in custody, they would have to pay the bond. And they couldn't write bonds until they were off the board, which means they either paid the bond or they brought the person back under arrest. Okay. So they had that. They had to pay that fee. Then they had to pay a percentage to the insurance company. And there are a bunch of other ticky-tacky things that they had to pay. So that $1,000 that they collected, they maybe got $400 out of it. So needless to say, they wrote a lot of bonds. But that was, frankly, the good old days, so to speak. Everybody used bail bondsmen. And you don't show up for court with a bail bondsman, they come and find you, right? Because they don't want to take you to jail and not pay the bond. But if you're on a PR bond, who's going to come collect it? The state? No, they're not. I mean, maybe if there's a warrant, but they're never going to collect the money. And the state, if you're on a professional surety, they want the person. They don't want the money, frankly. All right. Although we're in a severe deficit, maybe they would take the money these days, but they never used to want it. So anyway, but the bondsmen, they would do some sleazy things. So after they've earned their money, after 10 days, they'd be like, oh, I feel insecure with this person on bond. I'm going to revoke your bond. Keep the money, take the guy back into custody. There were some real scumbags, all right? And they didn't really police themselves, which was a problem because a lot of them were all scumbags patrolling scumbags. Now, there were some good ones, and I'd like to think those are the ones that I dealt with. I had one bail bondsman. She was amazing. I mean, I'd be like, hey, this is between you and the bail bonds person. If she can get you out, you guys have enough collateral, so you do what you want. They would call, oh, you're Scott's client? Done. I'll have you out, and we'll do the paperwork when you get out. There's real good ones. And I always said, don't bond this person out just because I referred them to you. You need to make sure you feel secure because I don't make any promises as to, whether they're going to stick around or not. Okay. And going back to the good old days and the bonds days, somebody would get out, they have like a $50,000 cash bond. Literally, I've seen where people would take trash bags full of money, give it to the bail bonds person. That person bonds out. Maybe they got sent to immigration and then they got deported, or they bond out and they're like, hey, man, I'm out. I'm like, no, don't do that. As an officer of the court, I must tell you, you must show up. And they're like, that's what you told me. And the bail bondsman was like, it's okay. We're good. It was crazy during those days. Now today it's kind of boring. Anyway, so then you got the bail bondsman. All right. So the bail bonds person is going to take this 10%. So Barry's got a $3 million bond, 10%. You think, only $300,000 to get out. I can do that. My last bond was $500,000. I can post that easily. Ooh, but there's a catch. You think that bail bondsman's just going to take that $300,000 and say, we're good? No. A bond that big, it's not just that little bail bondsman that's going to have to write that bond. They're going to have to go to their insurance company, one of their head underwriters, and say, what can I do to write this bond? And guess what that attorney at the bail bonds company is going to say? Oh, you got a $3 million bond? I need $3 million in collateral. You got a property worth $3 million, free and clear. We're going to put a lien on that. So if you skip town, we don't get you, I'm going to foreclose on your property. So the bond is technically lower because if he goes through a bail bondsman, it's 10%. You may even find somebody to do 5 or 8% on a big bond like that. But the reality of it is the insurance company, it's not just some Joe Schmuckatelli bail bondsman, just use your imagination of what most bail bondsmen look like. They don't usually show up in shirt and tie. They're usually some rough characters. All right. A lot of them had felony convictions or skirted a felony conviction. A lot of them had issues with the regulatory agencies. They're a unique group of individuals. Some of them did bail bounty hunting on the side. Others, turned all that stuff over. They would be very restrictive on what people did. You have to call in every day. You're going to wear not only the court's GPS, you're going to wear my GPS. You need to check in every hour on the hour. If you don't do that, I'm going to revoke your bond. Right after, of course, the 10 days, they get to keep their money. So lots of different things going on there. But, they're ultimately responsible for the person if it doesn't show up. And that's kind of the argument the bail bonds people made in the state of Colorado when they basically tried to abolish them, basically saying, get rid of all these bail agents because they're all a bunch of sleazy scumbags. And they're not all that way, but a lot of them were. And a lot of them have gone out of business. They've gone to do other jobs because of that. And they tried to get rid of them. But guess what? The only people that really thought that they would, if you didn't show up for court, the only person that really cared that you didn't show up to court usually was the bail bonds person, because they're on the hook for it. So they're going to come find you. And in the little clause, they have to send bounty hunters out to get you. Guess what? Then you got to do it. And bounty hunters are a whole different breed in and of themselves. Okay. Every now and then you hear of a bail bonds person usually breaking into somebody's house, charged with burglary, maybe shooting somebody. It just gets wild west when it comes to bonds people and bounty hunters. So anyway, the bond, $3 million, only have to post, probably 300,000. Some surgeon is going to want 300,000 in cash, but they're going to want that collateral. So the question is, will Barry Morphew be able to actually post his bond? Because it's not just 300,000. It's 300,000 to the bail bondsman, non-refundable. That's their fee. Doesn't get it back like last time that they posted the cash bond. That goes to the bail bonds person. And they're going to want $3 million in collateral. So unless they've been working on this, for the last several months while Barry Morphew has been in custody, that's going to take some time. I would predict if Barry Morphew gets out, it'll probably take him 2 to 3 weeks to get that bond posted. We'll see. If I'm wrong, I don't know. I did say on the show today, we did the show before the Barry Morphew hearing, I said the bond reduction would more than likely be denied. I guess it was technically correct because the judge did deny the bond reduction, but she modified it to include the, cash surety, which is a bail bonds person, or property. So she didn't reduce it. She modified it, which I guess I was technically right. She denied it. So let's take another stroll down the courthouse lane here real quick. And then I know we got a call. We'll get to you. The judge who's handling this case is the chief judge, Amanda Hopkins, there in Alamosa. She is the chief judge of the 12th Judicial District. So she was appointed back in August of 2023 as the chief judge. All the chief judge is, sounds fancy, but it's a headache. In the bigger jurisdictions, chief judges don't take cases because there's an administrative nightmare that comes with it. You deal with budgets, you deal with hiring, personnel issues, disciplinary issues, security, building maintenance, all that stuff. That's what comes with the position of a chief judge. Some people want that job because they're tired of being basically lawyers on a regular basis. And once they become a judge, they're like, ooh, sign me up. Ooh, I want to be the chief judge. Okay. Other people are like, oh, why do I want to do that? I just want to be a judge. Anyway, she took over after the other judge there resigned. And let's see. Judge Hopkins was appointed to the district bench in 2018. So she's been a judge for about 7 years. And she, prior to her career on the bench, her legal career began in 2007 when she was a deputy public defender with the Alamosa office of the Colorado State Public Defenders, where she represented juvenile and adult clients. And then in December of 2011, she was named the managing deputy public defender for the Alamosa office, which is basically, once again, you're the office head, you deal with administrative stuff, it gets you out of the courtroom. Anyway, she divided her time between those administrative matters and representing people accused of felony crimes. She got her degree from the University of Puget Sound in 2001 and her JD from the Seattle University School of Law in 2006. So she's been around for a little while, right? 19 years as a lawyer, I guess, if I do my math correctly. She's been on the bench since July of 2018, which is about 7 years. And it looks like she was a public defender for about 9 years before becoming a judge, which is good experience. And you may say, oh man, Barry Morphew is going to get everything he wants. The former judge is a public defender. Oh my gosh, this is going to be great for Barry Morphew. Maybe. But let me give you an alternate theory when it comes to public defenders and judges. Okay. Now, I've had this conversation with many colleagues many, many times. So I'm not sharing something here that, and I've mentioned it before, but the general rule is the criminal defense bar generally concludes that former public defenders make terrible judges. It's just true. It's just fact. All right. And it's always the ones that you thought would, when they got to be a judge, you're like, oh yeah, because they got screwed so many times. I remember hearing them bitch about things all the time. Oh, this is going to be great. She's going to right the world, all the injustices of the world. No, doesn't happen. All right. When people leave the practice of law to become a judge, all right, there's a couple of reasons why you want to do that. Now, normally it should be like, hey, I'm in my twilight years. I want to give back to this community. I made enough dough. I don't need to do, private practice gig anymore. And it'd be nice to retire with, judge, in front of my name, right? That's what you usually think about it. Well, no, not really. Some people, they come out of law school thinking, I want to be a judge immediately. I want to fight for justice. I usually want somebody that really loves the practice of law and truly loves the law. And, here's the facts, here's the law, let the results be damned. You're just going to follow the law. And other people become judges because, well, like prosecutors, they kind of, usually kind of like the whole power thing. And they want to be able to do these sentences that, they could never get the judge to give them when they were the prosecutor. And I'll be honest with you, the prosecutors, they're usually better judges. I hate to say this. I mean, I'm a defense attorney at heart. I'm telling you, but defense attorneys make terrible judges. Prosecutors make better judges. People that have only done civil work usually don't make great criminal judges because they're scared to death. They, don't want to deal with the impact of sending somebody to prison for the rest of their life or a lengthy sentence, but they usually defer to the prosecution in whatever they want to do. But prosecutors, they get it. They've been around the block. They know what's serious and what isn't, right? You got rape, murder, violent crime, and everything else. And everything else usually can be resolved short of a trial, but sometimes you got to go try it. Public defenders that go and off to be judges, and I know this is a generalization, so take it for what it's worth, grain of salt, right? But the reality of it is they leave because they're sick and tired of hearing all the excuses. And I know that sounds terrible, right? Coming from a defense attorney, but sometimes I'm telling you, if they could mic up, it would be like on the sidelines for like NFL Sunday. If you could sit and hear attorneys chatting amongst themselves when other cases are being called. Oh my gosh, I can't believe that guy got such a sweetheart deal. My gosh, what happened? Oh my gosh, I'd lock that guy up forever. Oh, it's terrible. Oh, it's terrible. That's the way defense attorneys, they're very candid. They just tell you the way it is. right? You want to sugarcoat something. I don't know. Go talk to like a divorce attorney or something. It's all going to be okay. All right. No, not with criminal defense. We just tell it the way it is. So I'm telling you the way it is. Generally, public defenders make terrible judges. Why? Because they've heard it all before. They have like mitigation fatigue. They got excuse fatigue, and they've heard it all before. And so, you know, they get to the bench and they're like, yeah, sing me a sad song. Oh, here's my little violin playing. They're like, heard it all before. We all know past performance is indicative of future results. And guess what? You failed miserably on probation 8 previous times. I'm not sure why this one is going to be different, even though this time you say it is. You say you found God in the jail while you've been waiting. But let's all get realistic. You're not going to change. You know, let's just cut to the chase and send you to prison and get you over with. Let's not waste the resources. Okay. So do I think that, Barry Morphew has hit the windfall, the lottery, so to speak, because he's got a former public defender as a judge? No. And remember, her job is to follow the law. Now, remember, this case got moved out. Now we're in Alamosa County. Alamosa is a little different county. All right. Done a couple of cases in Alamosa. It is a, so Alamosa is growing. Once again, should have bought property there 30 years ago. Has a nice little airport down there. Flown in there many, many times. Okay. It's, the judicial district for Alamosa covers several counties, several smaller counties, and they have judges that rotate out. For example, down in Telluride, San Miguel County, Delta, I think, is also covered by that one. Anyway, so the judges kind of rotate. They ride the circuit is what they refer to it as. But it is a very, very conservative jurisdiction. And let me tell you my 2 experiences I've had for one. One, it was a double dead baby case that I represented. This kind of almost like religious cult thing. It was really kind of weird. Anyway, that took place down in Telluride, or the little county just north of that. But the judicial district was in Telluride. And we've got to change the venue because publicity was just run rampant. It was crazy. And even the judge was like, yep, we can do it. But instead, in that particular case of the case getting sent to the Supreme Court and the Supreme Court saying you're going to go to whatever county it is, the judge says, I have a problem. As a judge in this judicial district, although I'm in the Telluride and in not San Miguel, whatever it is. Anyway, I'm going to move it to Alamosa. And I'm like, okay, seems fine to me. It's going to be a month-long trial. I'm down for it. You know, my associate and I, we get an Airbnb. All is good, right? We're there for a month. Very conservative jurisdiction. And I don't know, let's just say the population is very white, very conservative. And my client was not. And he was some sort of religious cult hippy dippy guy. But he ultimately got convicted along with, I think, 5 other co-defendants in the case where these 2 children basically died. And when the sheriff was there, they were mummified, literally mummified in the car. It was a horrific case. Made papers. It was like international news for a while. But anyway, it is what it is. Got a fair trial. At least I thought so. I wish the appellate people had done a better job, but hey, that's on them. Anyway, the other case I had was a self-defense homicide case. Little road rage incident on a little rural road. Let's just say there's 2 guys on a road. Only one walks out. And what do I say? The jury promptly found my client not guilty because there were 2 witnesses in the case and only one was showing up to court. It's that simple. And I remember asking the DA, the elected district attorney at the time, saying, why are we doing this? How do you intend to disprove self-defense? And my guy did everything right. Guy, threatens him, comes at him. He shoots him, 1 shot in the eye, drops like a sack of potatoes. Boom. Right. And then he did everything right. Oh my gosh, I need to call the police. Guy gets cell phone service. I got to run to the top of the hill. Did everything right. Hey, there's been a shooting. It was self-defense. Come quickly and don't talk to me because I want a lawyer. Beautiful. It was the best facts ever, right? That's why I was not guilty just like that. Once again, Alamosa jury didn't buy it. Now, you got to remember, a lot of these people down there in the Alamosa area, they're pretty skeptical of the government, all right? But they're also law and order. So it depends on who they get, all right? Probably have to bring in a pretty big jury pool. On the one trial that we did down there, I think they brought in 600 jurors because there was so much press about that case. And, you got 2 young dead kids, I think both under age 10. Just bad, weird religious cult thing. The world's coming to an end. Just got really weird and ugly. Anyway, our client did get the least sentence of everybody else. Everybody else was convicted of murder. We got child abuse resulting in death. So we got the least sentence of any of them. Okay. But it's an interesting jurisdiction. All right. Now, let me tell you another case I had down there. Represented a guy in Alamosa accused of stealing another man's horse trailer, ladies and gentlemen. And I'm not talking like a little horse trailer. Apparently this was the Mac Daddy of all kinds of horse trailers. All right. And apparently there's one thing you don't do in Alamosa County, along with most states regarding livestock. You don't touch another man's wife, and you certainly don't touch his horse trailer because they are about the equivalent of the same crime. It's not tolerated. So anyway, had a guy who, allegedly and ultimately, pled guilty to stealing a horse trailer they found and what have you. And there's vandalism and everybody showed up. Even the people in the back of the courtroom wanted to send he should have killed somebody. All right. But he stole a horse trailer, right? The other criminal defendants were in the back of the courtroom like, oh man, I mean, if you had distributed some drugs or, maybe stole something, like anything but a horse trailer, man, like we're kind of with the prosecution on this one. You got to go to prison. That's just not cool. Stealing a man's horse trailer. I swear to God, not making it up. Don't mess with the horse trailer. So at least I guess Barry Morphew in this particular case will have a bunch of people. He can get up and at least say, at least I didn't steal anyone's horse trailers. He is just accused of killing his wife, which obviously he's entitled to the presumption of innocence. All right. Anyway, so that's a little bit about the Barry Morphew case today. A little bit about the area, the judge. Hope you enjoyed that. Frank, you said we have a call. They hung up. I apologize. I was getting a little carried away talking about Alamosa County. But it's a nice, Alamosa, Montrose. It's all it's all a good area there, to say the least. Anyway, it's going to be interesting. And Alamosa, you got Montrose, you got Alamosa. Yeah, we went down to Alamosa once, and I remember I had an associate. And we flew the plane in there, and the winds were so bad. We're like, we got to get out of here, right? Couldn't get out. The winds were so bad, so we wound up renting a car and driving back. And they said, "Hey, you got to get your plane out of here because otherwise the airport's going to be closed for like a month." And I'm like, "Oh my God, I gotta do that." So anyway, they had a little, I would say, regional or charter flight or something out there. So I get up there early one morning, Saturday, go get my plane, take off. And those moments where you're thinking, God, I wish I were on the ground. That was one of those moments, probably one of the scariest moments ever coming through Alamosa there for sure. And I guess I had another case in Alamosa as well, where the guy was threatening my client because he was apparently separated from his girlfriend. The girlfriend went with my client, And literally, this is something out of a freaking movie. My client says to her husband, "Bart, get me my bullet." And the guy gets out, like, "Where's my wife? Blah, 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 blah. I'm going to do whatever to you." And she takes aim, says, "Don't take one more step or I'll shoot you." Boom, shot him right through the heart. DA's dismissed that case about a week before trial. And they would have lost. They knew that. That's why they dismissed the case. It was total self-defense. But it was something, I mean, it was like one of these old campers from the 1970s racing around, saying, "Where's my woman? Bring me my woman." And, the house had like no running water on it. It was literally like a trailer out in the middle, right next to the Great Sand Dunes. It was amazing. Like, you can't make this stuff up. I love this job. All right, we have a call. Who do we have, Frank? Annie, are you there? Hello.
Yes, I am. Can you hear me?
I can. How are you, Annie?
I am great. I had a question, sort of about jury selection, because I was watching it in the Adelson case, but it's not about that. It's more about you, because I know you're a practicing attorney.
Mm-hmm.
So do you ever have, like, the opposing counsel, like, ask people if they follow you on any of these platforms and maybe throw them out because of it?
It's funny. I think only had one potential juror that said, "I follow, Scott Reisch on YouTube." And of course, everybody in the courtroom looks around like, "Really? Like what?" And I have to explain, "Yeah, I got a little YouTube channel, blah, no big deal, Your Honor." And they usually dismiss that particular person. But one of the questions that the judge usually asks, "Do you know anybody in this courtroom?" And that's when it would usually come up. What I usually get it through is walking through the courthouse. Somebody will say, "Oh my God, you're Scott Reisch." And I'm like, "Yes. Hi, how are you? Thank you. Pleasure to meet you." That type of thing. And I usually should say, I should say, "Oh my gosh, would you like to get a picture? Get your phone out, whatever." But usually it's kind of weird because I'm really calm about it. Like, "Oh, thanks. I appreciate it." And the other person's usually like, and not say like in shell shock or something. It's very surprising to me. But I'm like, "All right, calm down, take a breath. It's okay. It's just me, just Scott." And then they, usually like, "Oh my God, I can't believe I met you," and they walk away. I'm like, "Okay." And I should say, let's get a picture together or something like that. But that's usually where it happens, is somebody walking through the courthouse, something along those lines.
Okay. I was just curious.
Yeah, I mean, I would have no problem, but I mean, normally, I guess if they would say they know who I am, that's fine. They would usually disclose that. I have no problem. I would have no problem with that. And the question is okay, that's great, but could you be fair and impartial to both sides, regardless of what you may have heard Scott talk about? So it's all good. It all works out.
All right. Thanks so much. Enjoy the show.
Well, thank you. Thank you very much. Poland. Well, I forgot to tell you, Frank, we got a card today before we take the call from Poland. We got a card today from somebody in Austria. It's on my desk that says that she watches from Austria. She enjoys the program. Sent a card. Can you believe that? And I see somebody who says they're watching the replay from the coast of Georgia. Lovely. All right, let's go. Hello from Poland. Are you there?
Hello?
Hello? Who do we have?
Hi, my name is Olga. I'm calling from Poland.
Well, thank you,
Europe.
Olga from Poland. How are you?
I'm sleepy a bit because it's 3 a.m. in Poland. How are you?
I'm doing wonderful because it's only 6:55 here in Denver, Colorado.
I was made aware of that thanks to all of your wonderful people in the chat room. I was asking them, how do I get to call you and what time it is in the United States where you are. So apologies. English isn't my first language, so I might make some mistakes. But I wanted to ask you 3 questions. Okay.
All right, go ahead.
The first one is Sarah Grace Patrick. You know the case? Do you recall?
What was the case?
The teenager who allegedly shot her parents and is right now number 1 suspect.
Okay.
I was wondering if you think she actually did that.
Is this the case down in Mississippi?
Your defense? I'm not really sure. She's the girl. She's a teenage girl who has a 5-year-old sister who went to find out their parents who were shot, and she made a eulogy at the funeral, and then she made a whole story in TikTok, and right now she's the number 1 suspect.
Yes.
She allegedly did shot her parents, her mother and stepfather.
Yeah, the Georgia teen charged in the death of mother and stepdad, right? Yeah, that's it.
Stepdad, yeah.
Yes, Sarah Grace Patrick, accused of killing her mother, Kristen Brock, and stepfather, James Brock, back on February 20th. Found shot to death after Patrick's 5-year-old sister discovered their bodies, and the teen called 911. Yes, she went to social media.
Exactly. Yes.
Attention about the case, searching for the killer, and she has become the suspect. Yes.
Do you think she did that? I know it's a tough one. I know it's a very straightforward question, but do you think she did that?
Well, she got arrested, correct?
Yes.
So she got arrested, so there was enough evidence for probable cause to exist. Would a reasonable person reasonably believe that a crime is committed and that the defendant may have had something to do with it? Pretty low standard. A lot different than proof beyond a reasonable doubt. But I believe that because they had a bond hearing not long ago, and I think she was a little surprised that she got her bond denied.
Yes.
I think the prosecutor's saying that she kind of planned this out, tried to, set the whole scene and stage. I mean, I would probably be leaning towards probably yes, that she did. I mean, I don't know. It's been a while since I looked at it in any great detail.
Okay, because I was wondering what would be your defense, criminal defense, in that case. But if you're not that much into the case.
Well, I just haven't followed it in a while because I don't think we've had a whole lot of breaking stuff lately on it. But, remember, there aren't that many defenses, actually, when it comes to a defense case. Usually it's a general denial saying, I didn't do it. Then you have affirmative defense. Then you have affirmative defenses. A general denial is you got the wrong person. Wasn't me. That's all you have to say. Not guilty. So you got general denial. You have affirmative defense, like I did it, but I was justified under the law, right? Self-defense, something along those lines. And then you got, some mental health, not guilty by reason of insanity defenses. So her defense in this particular case is going to have to be, I didn't do it. You got the wrong person. I'm being wrongfully accused. And, that's always a great way to start a jury trial opening statement. Ladies and gentlemen, my client has been wrongfully accused of a crime that she did not commit. And, you give a jury a great enough injustice, they will find a way to correct it if they believe you. If they think you're lying, though, they will punish you hard. So they're going to have to go with wrong. You got the wrong person.
Okay. Okay, I understand. Okay, I have another question because
Okay.
I called here with three different questions. The second one is because in Poland, in Europe, we have a kind of a little bit different jurisdiction and a little bit of different, what do I call that? Like, legal stuff. What's with the pictures from the crime scene? There's a whole thing because I'm trying to write I'm studying criminal justice.
Okay.
It's my third MA. So it's not my first one, but I'm trying to write a thesis about maybe criminal profiling or stuff like that. And I was wondering, what's the deal with the pictures, crime scene photos?
Are you talking about the Kohberger matter?
Yes.
Yeah.
Yes, totally.
So normally here,
because there are people who are trying to forbid from releasing those photos. And what's with the law in the United States about that?
Sure.
Is the family really eligible to, block it?
Well, according to a judge, yes. So it used to be that when a case was over, you could get the discovery in a particular case. And, it usually was no big deal. Remember, all our records used to be, public, very public, because you used to have to go check out the file to take a look at it. And they would at most have a little section for like the judge's notes that they would hold on to. But you could go see all the pleadings in a particular case. It wasn't until we started getting to the digital age that they started redacting the files. And obviously, we're not going to get all the discovery while the case is pending. But usually when it was over, the press would immediately rush off and say, we want the entire case file. All right. And that's normally the way it worked. And then they would start redacting some things, some names, social security numbers, things like that. Got it. That makes sense. Okay. Or at least the last 4 digits of the social security number, redact it. Then there's all this big privacy stuff. Oh, it could be sensitive. Oh my gosh. I'm of the mindset that it should be released. Now it should be done with some tact, right? It should be tasteful in some way. But guess what? They're crime scene photographs. They're probably going to be messy. I once had a prosecutor say in the case that, sorry about all these crime scene photos, but guess what? It's a homicide. That's what you get to see, the brutality of it, right? Now, should everybody if anybody wants to see these photographs, I'm of the mindset that they should be able to see them. That's just me. So other people say, no, nobody deserves to see it. They shouldn't be able to see it. But part of living in a free society is that you get to see how the government conducts their business. What's one of the best ways to see how the government conducts their business? How do they prosecute crime? How do they investigate crime? And yes, it's gory. It's messy. Fine. Redact the little photos. Oop, can't tell who this person is, right? Obviously, we don't need pictures of intimate parts or something along those lines. But the reality of it is a crime scene, and it should be made public after the case has gone to trial. That's my humble opinion. But everybody keeps saying, and we see more and more of this nonsense that everything in our system somehow, is getting whittled down to everything needs to be more and more private. Like if you're going to put somebody's name in a motion to argue for your bond, right? Like in the Morphew case like we talked about earlier, then by God, it's public record. The public should have a right to know who's going to support this guy, whose house is he going to reside at if he is there, because we should get to know. What if, it turns out that isn't a factual statement? What if the person can't have somebody reside there? The prosecutor's probably not going to go check all that stuff out. So who's the best people to do it? Usually, normally the people they read about, like, no, that's not right. I know that guy. He can't, keep somebody there. So, like I said, there's a dispute, and I understand both sides of the argument. I get it. If I was a family member, I'd probably say, oh, I don't want that out there. it's going to cause trauma to me, thinking about everybody's looking at it, etc. But then again, in a free society, guess what? We should be able to get to see things that upset people. That's just my humble opinion. Judges disagree with me on that. But I hope that we're moving back towards a little bit more openness than restrictions, because I think the public has a right to know. I think the people should, if they want to see the photos, and maybe it's good sometimes when people see the brutality of a murder, and you see when somebody's been stabbed 52 times, and you think, well, maybe he's really just a good guy. I just really don't, I'm not sure it was his car. So I'm just kind of convinced that, sometimes those people need to see the brutality and what, that guy pled guilty to. And, is an eye opener, because there's so many people that live in little bubbles and they live in make-believe land that nothing bad ever happens. And, it's all, gumdrops and lollipops and rainbows. And it's not. The world is a dangerous place. And the only way you can realize it's dangerous and create the correct public policy for it is if you actually have the truth and know what's going on. I know it was a long answer, but does that answer your question?
Yes. And I need to tell you that I really appreciate your stand. I came across Crime Talk. Really, I'm from Poland, Europe. I really accidentally came across Crime Talk, and I am addicted. And I need to tell you that yesterday, when you did not do a show, to which I either fall asleep or wake up to, I had an anxiety attack, and that's on you.
Well, thank you. We appreciate that.
But I really, really enjoy your show, and I really, really appreciate all your work. And I also want to thank you for your service, because I'm also in the military. So whenever I hear about the K-bar knife, and whenever you talk about your boot camp, I feel like I can relate. But going to my third question.
Sure.
Having said all of that, all of those nice things to you, in front of all the chat people that are there, like 300, and all of those people who will watch this show on YouTube, would you be willing to give me a short interview for my MA thesis at some point?
Sure. Absolutely. Why not?
Okay. So everybody heard that. So
yeah.
I am very, very thankful. I will contact you. I am very, very thankful for all your work. Really,
thank you.
Really, it's a joy to listen to you, to all your reasonable talk. There's a lot of reason, and there's a lot of sense and intelligence, and I really, really appreciate that. And I want to thank you for all of that. And for me, watching all your show from Europe, it's really refreshing and something I can really enjoy. So thank you. And I wish you a wonderful afternoon or evening, because for me, it's almost, the sun is rising in Europe right now.
Well, the sun has set. The sun has set here. And let me just say, my son is in the Air Force. He flies F-16s, and he's stationed in Germany. But he has gone on several deployments over to Poland, and he says he loves the Polish Air Force people over there. So he says he loves the Polish people.
Just please, let me know when he's here. I can show him around. And also, if I may ask, oh my God, this is live, but is Reisch a German name?
That's what they say.
Okay. So I wish you all the best. Thank you for the talk, and I'll be watching this show tomorrow morning.
All right.
It shows on my YouTube tomorrow morning.
Sounds good.
All the best, and thank you for the conversation.
All right, thank you, and reach out to Frank, and we'll set up a time for the interview. All right.
Okay. Thank you.
Thanks. Another call, Frank? All right. Who do we have?
I don't have a name.
Okay. Hello. Who do we have? Hello.
Hi.
You're on the air.
Hi.
How are you?
Great. I'm good. How are you?
Better than I should be.
This is Misha from Maryland.
All right. Misha?
Yeah, I was just wondering I keep hearing about, there's a big hubbub about Bryan Kohberger possibly being able to appeal, even though he waived his appeal status, during his, plea agreement. What would be any grounds of appeal that he could do that would be able to circumvent his waiving of his appeal? Would that be just things that were going on in the prison right now, or is that something that would also happen to be with the case?
Nope.
And if somebody's pleading guilty, how can somebody be appealing something if they've already pled that they've done something?
Well, I mean, that's the benefit of a plea bargain as it relates to both the state and the defense, right? He pleads guilty. He gets something in exchange for that. What did he get in exchange for that? They'd agreed not to pursue the death penalty, which he must have reasonably thought was an option. Otherwise, they would not have pled guilty to 4 counts of, murder, getting a consecutive life sentence times 4. All right. Now, normally, when one pleads guilty, you give up your right to an appeal, with one exception. If there was an illegal sentence imposed, but you wouldn't even have to do an appeal in that regard. You would have to just simply file a motion to correct an illegal sentence. So if the judge says, I'm going to give you for one murder 2 life sentences, that would be illegal. But the judge didn't do that. The judge is aware of that. So that's why he got 1, 2, 3, 4 life sentences, plus the 10 years for the burglary, all consecutive, completely legal. There's no legal basis on which Bryan Kohberger could appeal. None. Zip, zilch, nada, nothing for him to appeal. All right. The only thing
So
that he,
essentially,
go ahead.
I'm sorry, but essentially for his, because I keep hearing people that are, other, attorneys that are online reviewing the case or analyzing what happened, frustrated because they said that Idaho has a stance to where you still have a right to appeal even if you waive it. So essentially, it's like he would have a right to appeal something, but even when he has the right to say, oh, I want to, never mind, I want to appeal this, it's not going to ever actually affect anything of the case because he's already waived his right to be able to appeal anything in the case.
Listen, it's what they call an appellate waiver. Appellate waivers they're nothing new. All right. They've been around. Normally, oftentimes prosecutors will put into a plea bargain. There's no motion to reconsider. There's no, appellate, unless, of course, there's usually 3 exceptions, right? Like in the federal appellate court waiver is you waive your right to an appeal unless the court imposes an illegal sentence. Okay. You find out there was some prosecutorial misconduct. If you come about that, or third, basically your attorney was ineffective. Okay. So 1 was no illegal sentence. 2, there was no prosecutorial misconduct. Sounds like prosecution for the most part was pretty much on top of everything and gave the defense everything they were entitled to, plus some. And third, then you would have a right if you had ineffective assistance of counsel. Ann Taylor was not ineffective unless it was found out that Ann Taylor is not really Ann Taylor, but maybe she never had a law license. That would be one of the only grounds to do that. Frank was great enough to pull it up. Here it is. Pursuant to the plea agreement entered by this court on July 2nd, 2025, defendant Bryan Kohberger waives all rights to appeal any and all issues in this case and waives the right to file a motion pursuant to Idaho Crim Rule 35. There it is. There's the Rule 35 is normally in most states ineffective assistance of counsel. Nonetheless, should defendant elect to file a notice of appeal, it must be done within 42 days from the entry of this judgment. You're further notified that you have the right to be represented by an attorney in any appeal. that if you cannot afford or retain an attorney, one may be appointed at public expense. Further, if you are a needy person, the cost of appeal may be paid for by the state as indigent. And if you have any questions for your appeal rights, you should consult your present lawyer. So July 2nd, he would have 42 days. July, so that would take us through 38. July, August, here we are, September 2nd. Just like I predicted, he didn't file a notice of appeal because it would reinstate all the charges. And the time has lapsed. And even if he did do it, I mean, you'd have to show excusable neglect at this point. And just because you don't like the prison that you went to and they're treating you mean because you're the new guy on the block, that's not a basis to appeal.
So in essence, like that's kind of like an even bigger like proof for all the people that are pro burgers, you know, in this case, to actually realize, hey, this guy, he's savvy enough to understand the law. He's savvy enough to understand what he's agreeing to. He knows that he's basically saying he is guilty outright. There's no possibility of him being, you know, misjudged or misrepresented because he's agreeing to the fact that none of that is happening. So for all the people that are placing that on this case afterwards, all they're doing is just creating a bunch of chaos and
they're trying to get clicks. That's what they're trying to do.
Yeah, because that's one thing that I've noticed because I love your channel. I follow your channel. I follow a bunch of people that are at least logical and reasonable with what they're saying is happening, and you can know from just experience what's going on, and then to see the people that, you know, they generate something that'll be a video for 20,000 views of just 20,000 unfortunate people that will follow them, that they just, you know, sitting through one of the videos, it just becomes egregious to the amount of lying either through omission or just outright lying to where they kind of allow that perception to continue to perpetuate itself.
There's a bunch of shysters and, you know, hucksters out there that are trying to make a buck, right? You know, this isn't my day job. We originally started this because we wanted to educate the people on what's really going on. It was the Chris Watts case. And I remember seeing something on TV and some news reporter was trying to explain what was going on. And she didn't know the difference between a preliminary hearing and an arraignment. And I thought, God, there's got to be a better way to do this. So my friend said, you should try it. I'm like, nobody wants to listen to me. Nobody wants to watch what I have to say, right? Okay, fine. We did it. We've been doing it for, I don't know, 7 years now, I think, what we've been doing. You know, listen, we sit around here and I, you know, Frank and I, we chat. What should we do for a thumbnail today? And we could do something crazy, outrageous. But, you know, one thing you have to remember is I'm an attorney. If I did something so outlandish just to get a few clicks or views, I mean, I could potentially lose my law license. And I'm not going to do that. I have integrity. And a lot of people out there that are just trying to get the clickbait and, you know, have people come up with the most crazy, bizarre ideas. First of all, probably not an attorney. And if they are, they may really need to re-examine what they're doing. If they're coming up with just crazy, outlandish stuff. And then you have a bunch of people that never tried a case in their life. And not that you have to, you know, to understand the court system, you know, be a lawyer or try a case. But I'm telling you, it gives you a little more perspective on what you think is actually going to fly in front of a jury and what's not. And like I said, I love people in the true crime. I mean, I'm telling you, I've had true crime people that have sent me stuff like summaries of cases and detailed analysis that you're just like, wow, if you were local, I would hire you to be, you know, a paralegal. Okay. Because they have that passion, they have that interest in it, but they also keep it to the facts. And, you know, I remember during the Chris Watts case, there was a guy, he was, I don't know, he would go back and forth and I'd be like, really, if you know, your shadow theory is going on, by God, you should send that to the district attorney right now. and, let's charge other people that are supposedly involved according to this theory, or he didn't do it, right? But they don't, because they know it's hogwash. They know it's been manipulated, right? If you think you've cracked the case that the police were unable to do, why don't you drive down to wherever you are, go down to that local police department, drive out to Moscow, Costco, it's like Costco, Moscow, Idaho, and say, you know what? I think I've cracked the case. I know you guys are trained professionals, had all the resources of the state of Idaho, the FBI, but I, from my home office, have cracked the code, and I'm going to let you know who the real killer is today, right? Why wouldn't they do that? If it's so great, it's so accurate, why not? And don't get me wrong, I understand the power of the internet. It has solved cases that, yes, the police haven't solved, but you got to have a little bit of credibility that comes with it. And you got to have the facts, and it can't just be hyperbole. It can't be, well, if you think about this and that, and I just don't see how. You can't ignore reality, right? These facts don't just live in isolation, in a vacuum. You have to look at all the facts together. And like in the Bryan Kohberger case, it wasn't just, well, first of all, he pled guilty, ladies and gentlemen. Remember that. He pled guilty. It's a confession. It is a confession where he said, I did it. Is anyone forcing, threatening you, pressuring you to plead guilty in any way? Nope. Doing it on my own free will. Any promise has been made that the court doesn't know about. That's what they refer to as a sub rosa agreement. Nope. This is it, judge. This is it. Plead guilty. 4 life sentences plus 10 years. Bring it on. That's it. But you had his phone on, his phone off, car in area. His conduct afterwards, where they thought, maybe he was throwing the knife into the river, getting your car detailed. If you had your car detailed every Tuesday, every other week, and that was normal, right? But, just coincidentally after murder, you detail your car to where there's not a, speck of dust in the whole thing. You know what I mean? Little weird, let's face it. The knife purchase, where's your knife? It's not just one little fact. And some people want to say, like, you take a whole stack of all the facts, and a lot of people are like, well, there's this, there may be a stack this big of facts that are bad. But if you look at this one fact, I just think he's innocent. Okay, that'd be great, but you can't do it. That's like a couple of questions on cross-examination. But is that going to be enough to create reasonable doubt? And oftentimes people, they get into the zone, and I get it. I mean, when I go to trial, I jokingly refer to it as I'm going to check myself in at the penthouse suite of the Psychosis Hotel. Okay, we got the facts, right? Sure, it's not great. It's on video. Our client runs up to the person and shoots them in the back. That's right. Sounds like self-defense case, right? And by the time I get to trial, I actually believe what I am selling, okay? Because I have to. But the juries are smart. Juries are not stupid at all. The juries usually get it correct. And you may not like the result the jury comes up with sometime, but based upon the evidence that they had, they usually get it right based upon that. Like I said, I won a case back in May. I should have lost the case. The DA didn't show up. She decided to go on vacation a week before a big trial. I didn't. I stayed home and worked, right? I get it. It was spring break and you got young kids, but guess you got to cancel that vacation. Anyway, turned out great for my client. That's just the way it is. I out-lawyered her. I didn't out-fact her. I out-lawyered her. And, sometimes that works out well. Sometimes, it doesn't work out. But you can't ignore all the facts.
I definitely agree that I think in this circumstance, it's one of those, unintentional, I'm assuming from his perspective or his team's perspective, just a great outcome for just the old general society to not have to be drugged through this and continuing to add flames to the people that are trying to say he's innocent to where he's just finally saying he's guilty. So that's I think a great outcome of the whole situation. But just if there's any, I don't know if there's any time, but if you're willing to, was there anything that you read in the proceedings that as a trial attorney, as a defense attorney, that you would have said, okay, I could have at least made some hay with this in this case? Was there anything like that for you? Or when you read it, was it just pretty, cause I mean, everything that I've seen it's pretty cut and dry. Like it is very,
Yeah.
I mean, there might be some things here and there that might be kind of minuscule, that if there's at least one juror that is not complete sound of I don't know, kind of comprehension or at least common sense, would have at least said, hey, I have some questions on this. Would there have been at least one thing that for you would have said, okay, I'm going to drive this home and try to do this? Because I think the end result of the trial not going through is it kind of made all the people interested in true crime had it to where the actual case itself became null and void because, you know, he essentially said, hey, no, I did it. But was there anything, if you were on that team, if you were that, you know, lead attorney for his case, would you have said, okay, let's focus on this and let's try to see what, you know, let's roll the dice and see if this makes any sense?
Yeah. And I think that the defense team did a really good job. And I said, and I don't know which video it said, but when they went death, he had death penalty attorneys. And I told you this, most death penalty attorneys don't try cases. They mitigate cases to try to get life without the possibility of parole. Who was the guy, James something? He was the attorney in the Lori Vallow case, right? His goal was always just to get the death penalty taken off the case. And if you saw his performance in trial, I mean, I was just sat there aghast that I could have, and I didn't even have all the discovery, right? I had what was disclosed. I could have asked 100 more questions, better questions than what he did. It was like he was going through the motions because as far as he was concerned, he already won. He got death penalty taken off the table through, frankly, no work of his own. It was a bunch of discovery violations by the prosecution. But in the Kohberger case, there were some things that you could have made some serious hay about. Yeah, the ID, I probably would have hired, I'm sure they hired an expert, and litigated. I would have litigated the reliability of eyewitness identification much more thoroughly. I would have had an expert, to bring somebody in to talk about that. Like there's, like gun focus experts, like, when in ID cases, they're not necessarily looking at the person's face or looking at the gun. It's called gun focus. I would have tried to find an expert as it relates to the ID, as it relates to the roommates that were in there. As it related to the car itself, they got these experts. They're going to say it's the car. Really? Well, you can't really say, this is the best video you've got. It's a clear video, but you can't see the license plate, right? Oh, it's not missing a front license plate. Well, how many other states are there that don't have to have front license plates? And how many cars, I would have found out how many cars brought somebody in from Hyundai and how many white cars are there out there for that. Now they're going to say, well, but what are the odds it was him? Well, what are the odds it's not him, right? There's a lot of stuff that could have been done. I mean, like I said, I tell clients all the time, man, I'll do what you want. You want to go to trial? Let's go to trial. And listen, here's what you got to remember. If it was a perfect case for the defense, the case would get dismissed. The odds are usually greater that the prosecution's going to win if they're ready and able to proceed to trial. Why? They've got the facts. They've got the evidence. Yes, they've got the burden of proof, but they have an ethical obligation to only take that case if they believe that they can prove their case beyond a reasonable doubt. And frankly, the defense is supposed to lose, right? Because you don't want the prosecution prosecuting innocent people. So they try to do their best to get the right people most of the time. But they do lose and they do screw it up. It's not an everyday occurrence on every case, but it happens. All right. But yeah, you could, any defense attorney worth their salt could have got up there and made some hay on anything they wanted to, right? Even on the DNA, I could have made a bunch of hay on that. Okay. Yeah. It's a knife. Sure. You've got it. But, they should never mention, where is the knife, right? That's burden shifting. All they can say is, I don't know, maybe somebody broke into Bryan Kohberger's house and he didn't know about it. And they stole a knife and it had his DNA on it. I'm sure, own up to what you did. You betcha. We purchased it. But guess what? Somebody stole it. But I didn't report it because, I don't want to get somebody in trouble. I mean, you could have come up with so much stuff where, who knows? You find one juror that's like, I don't know about that. That could be reasonable doubt. That's why I was so disappointed that they didn't try the case. Okay. Do I think Kohberger ultimately did it? Yes, I do. I believe that. And I thought the biggest problem he had was the DNA. But I've done lots of DNA cases. I've won DNA cases. They're tough when that's the ID linking you to them. But you remember, the prosecution has to prove it beyond a reasonable doubt. They have to prove that it was him, not someone that looked like him, not someone using his identity, but it was actually him. Yes, DNA bad on the knife sheath underneath the victim, right? With no knife.
Yeah.
That's a bit of a problem. I'd be committing malpractice if I didn't point out that little bad fact to my client and said, unless we can really explain how it got there, like I can get up and ask my questions and try to raise reasonable doubt. But at the end of the day, they're going to say, what are the odds your DNA is on the knife sheath button to just happen to be underneath the victim, one of the victims, in a quadruple homicide? Oh, and by the way, where's your knife? And although, maybe you're not going to testify to it, those are going to be questions that a jury is going to be asking. And I always tell clients, listen, you tell me. It doesn't matter what I think. I'll go represent you on anything. I've represented some horrible cases on video, okay? It is, what do you think is going to happen? I frankly think the attorneys, and I get it, it's their client's choice. It's ultimately the client's decision. But what the hell did he have to lose, right? What are the odds of somebody actually getting sentenced to death these days? About slim to none. All right. I mean, unless you're in Florida or Texas.
Even that sentence actually being carried out as well.
Exactly. It's going to take the next 20 to 30 years. And guess what? After the next 20 to 30 years in prison, in solitary, Kohberger may be ready, for the firing squad there in Idaho, had he taken it. What did he have to lose, right? But remember, he's the one that told his attorneys to go talk with them, the prosecutors. He's the one that said, I'll plead guilty if you take the death penalty off the table, which means he reasonably believed, not only thought that he was going to be convicted, but he also thought that he was going to get the ultimate punishment of death.
Mm-hmm. Yep. It's essentially, it's the ultimate guilt by association for him, realizing that what he's associated with in terms of all the evidence against him was going to be the worst case possible for him. So
yeah, I mean, the DNA was the worst. If there was no DNA,
because that was one thing that when you were bringing up what you would have wanted to kind of grind into, I noticed that most of it was not DNA worthy in terms of, because I think that's the one thing for a lot of these people that are pro his side is they don't realize like that is just such a death nail in the coffin to say like, no, like this is it, like he's there. You can't be able to escape the fact that for some reason, somehow, people that he's not at all been associated with or connected to, he's connected to.
Yep.
After their demise.
Exactly.
And that's something that is just inexcusable.
If you were to go back and look at my videos when this case first started, right, 3 years ago, I'm like, it's going to be a tough case for the prosecution. They don't have, I can come up with all kinds of, cell phone experts, all this kind of stuff. And I think the defense did themselves no great benefit by saying, oh, we're going to come up with an alibi. I mean, an alibi is, it's who are you going to call to say that they were with you and it wasn't at the scene of the crime? But they try to come up with this,
especially when you're such a loner.
Yeah, they try to come up with this hodgepodge of well, he was out driving, looking at the stars. And then I was like, well, I guess it was cloudy that night and there weren't any stars out. And so the visibility. So they look stupid. And like I said, I've never had an alibi work at trial, because if it was a legit alibi, guess what? It would have checked out when you disclosed it and the prosecution would have dropped the case. Okay. And they didn't even have to raise that. All they could have just said was general denial. It wasn't my client. You have the wrong person. And, she overstepped. I think Ann Taylor overstepped you know, when she started saying, my client is factually innocent. Okay. I mean, that's a pretty bold step for a defense attorney to make, you know, that he is absolutely factually and legally innocent and, you know, didn't do anything wrong. And then, oh, by the way, he's going to plead guilty, right? You don't oversell your case.
Give her some type of leeway. You at least give her some type of leeway in the sense of, okay, she's trying, because I think if anything for these whole proceedings, it's just been them throwing the baby out with the bathwater. They're trying to throw the paint across the wall, try to see whatever sticks, kind of a thing. That was just her last attempt to, right before the trial started, to say, okay, let's really try to hunker this down. So then we can, if we come up to the prosecution to say, hey, let's get a deal, they'll at least say, okay, yeah, let's do a deal, because we can see like you're willing to do anything to try to throw some type of haze in this situation. Again, I'm sorry.
I mean, Ann Taylor and her team, and I don't want to sound like I'm, you know, I mean, listen, I'm sure anybody could come sit and watch a trial and say, oh, I would have done it differently than Scott would have done it. Okay. I'm not saying that. You know, attorneys have different styles. I think Ann Taylor is a very fine attorney. She made a ton of money on this case too, right? Think about that. She had unlimited resources on this case. At one point, she said,
"How does that work as a public defendant? Like, is that something to where, like, how do you make money on this type of a case? I mean, I'm not trying to put her on trial or anything, but like, how does that become something to her benefit?
No, I mean, so obviously, she was a public defender in this case, and then she left the public defender's office to go into private practice, and with a client base of one, Bryan Kohberger, right? And so instead of making her guaranteed salary of, you know, $100,000 a year, $125,000 a year, whatever she's made, I just made those numbers up. I don't know what they are, right? And then she's like, well, now I'm going to go be a death penalty attorney, and it's still not big money, but I think she got paid $175 an hour, right? So think about that. I'm going to make $125 a year, or I'm going to work on this case. We'll just round it up for easy numbers, $200 an hour. I'm going to work on it 10 hours a day. That's $2,000, probably works 6 days a week, right? Times she's making a little bit, pretty good money after that. Don't get me wrong. She's earned it, so to speak, but she probably woke up, started the timer, and turned it off when she went to bed at night. It was, you know, and then I think she had one other case that she got appointed to, another death penalty case. And that was one of the reasons why she sought a continuance. And the judge was like, why is that my problem? You took this case. Why should you take that? But, you know, a lot of these death penalty attorneys are so focused on mitigation. Don't kill my client. Don't kill my client. They ultimately concede basically that their client is guilty. And that's normally the case because most prosecutors don't take a death penalty case unless they think it is there's no such thing as a slam dunk, but a pretty high probability that they are going to get a conviction. That's just the way it is.
I just have, is it okay if I just ask one more quick
question?
Sure,
go ahead.
Yeah, sure. Thank you very much. Just what was any benefit or detriment to, I think, you know, from what I can remember, when he was initially had to make his initial plea, he said, you know, he remained silent and he had the judge essentially plead not guilty for him. Was there any benefit or detriment for him in the case to do that? Like, what is the, I guess, the ramifications of doing that? Or is that just kind of like him kind of forcing the court to kind of move proceedings along?
Yeah. In that particular case, if I remember the hearing correctly, the defense wanted more time before entering a plea. So they stood silent and the judge said, very well, I will enter a plea of not guilty on behalf of the defendant. That's it. And I know I saw a lot of news articles where you refuse to enter a plea like you're somehow being defiant. No, I could do that with my client. Your Honor, I'm not going to say anything, but if you want to enter a plea and not guilty, go ahead. Right. Judge, I need more time, but if you're going to force me, I understand, then we can proceed with arraignment. You know, it's not that big a deal. It wasn't anything. It wasn't like some great tactical decision, like they're going to gain an advantage. You know, he made the judge say not guilty because he's innocent. Well, you know, that could
it wasn't anything. Yeah, it wasn't any strategic move on his end to be able to have at least feather in his cap to say, well, I can appeal because I never ever actually proceeded and said anything in the case. It's nothing like that.
Nope.
That makes sense.
Like I said, they did what they could, the defense team, and they did a good job with what they had to work with, which wasn't a whole lot. It's one of those cases where, you have to look at the case and say, go to the client and say, here's what's going on. The prosecution says that, if you were to come with us with a life without parole, we'd probably consider it. Are you willing to do that? Going to have a long conversation. You're going to have lots of witnesses on the defense team, all taking copious notes, maybe even recording it if the client consents to it. So that if there's any issues about somebody promised him or beat him into submission to take the deal, it would speak for itself. But once again, that's why the judge engages in that colloquy when they plead guilty, right? Is this what you understand what you're being charged with? You understand the rights you have, the rights you give up, and here are the possible penalties. Is anyone forcing you, threatening you to get you to do this? Are you doing this of your own free will? This isn't the first rodeo, right? I mean, the criminal courts have been going since the days of the colonialists, but nothing has really changed that much. The law changes here or there, but for the most part, if someone's going to plead guilty, nobody, you'd like to think that nobody wants to convict an innocent person, right? The court doesn't want to be responsible for that. Hopefully the prosecutor doesn't. The defense certainly doesn't want to do it. But nobody pleads guilty to 4 counts of murder unless you did it. I mean, that's just the way it is. And if you want to have a fan club, you do like Ted Bundy, fight it all the way to the electric chair, right? I'm innocent. They've got it. Here we are 50 years later, and they're still making movies about Ted Bundy, right? And this little fan club. I'm sure he'd still have a bunch of fawning people if he was still alive. But, that's just the way it is. I don't know.
Yeah, well, thank you again. It's been a pleasure. And again, I enjoy your show and I enjoy your takes on everything. And it's always a great kind of Easter egg every now and then during your episodes to be able to just learn more about the law and just learn more about just how actual proceedings happen and things to know. And also when you're being kind of flamboozled by other people that might not know what they're talking about, just trying to get clicks. So,
yeah. And like I said, I mean, there are lots of good people in the crime talk genre. But there's also a bunch of shysters out there. And I just have zero tolerance for that. And most of these people don't know, which side to sit on in the courtroom if they had to go in there. So I just take them with a grain of salt. I just mind my own business and do my show.
Well, thank you. You have a great night.
All right. Thanks. All right. Frankie says we have another call and then we'll go from there.
Hi, my name is Kylie and I'm a 1L currently. And my question for you is what pieces of advice do you have for law students, especially first-year law students?
Wow. I just had this very similar conversation with a little mentee that I have from the law school here. We had a really good conversation about it. Can I ask where you go to school?
Yes, I'm at the Louis D. Brandeis School of Law in Louisville, Kentucky.
All right. Great. What area of law do you think that you want to practice in?
Criminal law, but I'm not too sure. They say that could change, but right now, criminal law. It
could change. I understand it. And the best way to find out if that's what you want to do is at some point after your first year, go do an internship. Go clerk in a law firm. Go clerk at the public defender's office. Go clerk at the prosecutor's office. Get that practical experience to figure out if this is really what I want to do. Okay?
Mm-hmm. I was fortunate enough to internship with a prosecutor, and so now I kind of want to look on the flip side, and I'm also interested in defense. I don't know which, but
yes, you should. I would highly encourage that. I would do as many internships, practical application stuff that you can. if they have clinics where you can represent, indigent defendants in municipal court or something where it's not particularly serious, but it's a big deal to the defendant. And you get to have the supervision of an attorney or a professor helping you through all those things. I would highly recommend you do that. I would also tell you that law school is important. Yes, it will teach you to think like a lawyer. Okay. But they don't teach you a whole lot of practical stuff. All right.
That's what I hear.
So you have to remember that, they'll teach you how to write a brief, to the Supreme Court, but they, don't teach you how to get it filed. Right. or how do you get the clients or how you get paid for it or something along those lines. Right. So you got to keep that in mind. I'm not saying don't study, but study. Okay.
Right.
And
no, absolutely.
And you all have something that we didn't have. When I first went to law school, Westlaw was new. We had attorneys that were like, what is this wizardry that you bring to us on this dial-up modem, right? It was a big deal. And I'm like, dude, this is the future, man. I can pull this case up and I can find 10 other cases just like it. Whereas before you had to go to the law library, get the digest, get the head note, get the case that was relevant to your jurisdiction, go pull that case, read it, and then try to find other cases that went along with it, etc. Right? So you guys,
that's horrible. I bet you got extensions on I bet your timelines are stretched out a little bit further than ours.
Well, yeah, you had to prepare for it. Yes, that's right. And if it was a book for class, you need that case for class. Sometimes that book would be missing or the pages would be torn out for that particular case because somebody was trying to gain an advantage in trying to get the only copy in the courthouse or in the school library. But you all have AI, okay? And I was having this conversation with this young student. She's like, well, I don't really, I want to make sure I really get a lot out of it. And I don't trust AI. And the professors say don't trust AI and this and that and everything else. And I'm like, no, I totally disagree with you and tell your professors otherwise. I will come and debate them on that. Okay. And because you have AI coming. And is it perfect? No. But if you can understand what it can do and its limitations, it is going to make your life so much easier, right? Now, certainly if you're going to cite a brief that AI gives you, you should probably go make sure that's exactly what it says, right? So you don't get some phantom case in there. But you should also utilize it because it's going to make you so much more efficient. And I remember in law school, you get a lot of people in law school literally went straight to teaching right out of law school. And frankly, they're not good at it. And I remember some of these professors were terrible. And I remember I had a civil procedure instructor who had never tried a case, but she was trying to explain the civil process, right? I don't think I ever learned civil procedure till I was taking the bar exam because I had to teach it to myself, basically.
That is horrible. Well, my civil procedure professor is phenomenal. He's a pretty renowned defense attorney in the area. And so that's honestly my favorite class because he makes it interesting.
Well, that's good. And I would also recommend take classes from adjunct professors, from attorneys that actually either A, still do it or have retired from doing it. Not some guy that, is on like his 5th degree. And now, because he couldn't get, a job in some, PhD in underwater basket weaving, he thought he'd go to law school and, really found his niche, right? And he's going to study, the psychology of mergers and acquisitions or something, I mean, avoid those people like the plague. Get the practical application, the adjunct professors, the people that do it. They're going to explain it to you so much better because they understand it and they can tell you, this is what it says, but let me tell you, this is how it works. And they don't tell you that enough in law school. Okay.
Oh yeah, absolutely.
Find a good set of people to study with, bounce ideas off of each other. And, remember, there's lots of smart people in your class and they're all scared to death. You're right. You're a 1L, right? You're probably,
yes, I am.
Just remember, you're probably sitting there thinking, what the hell am I doing here? Everybody seems so much smarter than I am. And guess what? Every one of those individuals has the same thoughts. Okay. No matter how smart they are,
I can see that.
they all have the same fears, and they're all trying to find their way around. It's all new. And even if their daddy was a lawyer or they took all these classes, they're still scared to death when that professor calls their name out and says, why don't you discuss, blank case, and be prepared to brief it.
Do you want to know something? People were not lying when they talked about gunners, because there are a couple people, like, not specific, just like I've noticed that some people like raise their hand and like ask a fake question so that they can be like, well, this is what I think, blah, blah, blah. And it confuses me. I'm like, I have no clue what they're talking about. Like,
yeah.
You get what I'm saying?
Yes. Gunners. There was a video that was put out years ago about gunners in law school. It was straight up true. Frank, see if you can find that video. I think it was called Gunners or something. Anyway, for those who don't know, there's always somebody that sits in the front of the class. Boom. They always have a question. They always have the answer, and always trying to look good. They're referred to as gunners. And there's always going to be those few, but guess what? They're just as terrified as everybody else. They don't know what to expect. And the professor says, well, what's on the exam? And the professor says, well, everything. I remember literally professor saying, well, is the exam going to be on like the first 5 chapters? And they're like, yes. Well, is there anything in particular we should study? The first 5 chapters, right? So, just take a deep breath, don't panic. Okay. Don't panic. And think about it. The law is actually, if you think about it, it's common sense, but most people don't have common sense. That's why they make the law so confusing, right? Think about it. Contracts. I'm sure you have 1 year, 1L, your contracts, right?
Contracts, Civ Pro, torts, and lawyering skills.
Yep. And so there you go. The first year package for that. And maybe next year you get constitutional law, and then you maybe start taking some credits or something, but you got to do everything that's mandatory. Think about it. Contracts. We used to have to memorize the consideration for a contract. A promise, act, or forbearance, bargain for, given in exchange for, benefit of the promisor, detriment of the promisee. Okay, that's consideration.
I feel like I need to add this to my outline right now.
Basically, what that means is I'm going to give you something, and you're going to give me something in exchange, right? And we all have to be on the same terms. Otherwise, there's no meeting of the minds, and there is no contract, right? Well, what if we have a contract, but it's misconstrued? Well, then we got to go, what's the plain meaning of it? We don't get to go into all this other parole evidence rule of looking behind the contract. The only thing that matters is what was signed, right? It's kind of like, is this a good contract? Well, I don't know. It doesn't really matter. You signed it already. But think about it. Just like in a criminal case, like the Kohberger case, right? Here's the plea bargain. Are you sure this is the plea bargain? Is this what you want to do, right? A promise, act, or forbearance, right? You plead guilty. We're going to withdraw the death penalty. So each side is giving something up, getting something in exchange for it. That's consideration, right? It's usually quite simple if you just think common sense. Don't overthink it. You'll do fine. Because normally,
so far I'm loving it. Yeah.
Yeah. Normally what's supposed to happen in the law is what happens. The person that comes in with clean hands, right? Didn't do anything dirty for either side. That's going to be where it comes down to, they're going to usually be in their favor. Just try to get as much practical experience you can. Go take clinics, do internships, something along those lines, and get as much practical experience and figure out, most things in life, you have to figure out what you don't want to do before you figure out what you want to do. And so go try as many things as you can. If you're, wicked smart, great grades on law review, and you get hired by, Perkins Coie for the summer, they're going to promise you $500,000 is you're a first-year associate. Go check that out. You may think, wow, this is really great.
Right.
And then you figure out that, wow, they want me to work 80 hours a week every week for the rest of my life. But guess what?
Yeah,
Welcome to the
that's
practice of
the
law.
thing.
You know,
Right. No,
there are no
absolutely.
9-to-5 jobs in the practice of law. There really are not.
No, absolutely not. I think I'm learning that from school alone. I spend all day at school and then I come home and I spend all night reading and doing homework. And so yeah, but
Welcome to the
I don't know if
practice
you're
of law.
familiar with. Oh yeah, no. I don't know if you're familiar with Kentucky, but the school is phenomenal. I'm super stoked. They're great people. So
Well,
it's gonna
great.
be a good 3 years.
Enjoy it. I mean, it'll go by really fast.
Thank you.
And really, at the end of the day, most people don't care what your grades were because nobody ever did, great. Not everybody got A's in law school. It's all bell curve type of stuff. It's usually just kind of natural selection, so to speak. You always got those super genius people, the bell curve, right? The super genius gets the A's, and then there's a C's, and then it comes back down, and it's just kind of natural selection. But just do your best. Focus on practical application. Use your common sense, and don't overthink it. All right. And you have the benefit of AI.
Thank you.
And if you don't understand a concept,
Yeah.
ask AI, explain this to me like I'm a third grader.
Right. Or like make me a chart, make me a visual, like different forms to kind of help you supplement your learning. And also last thing I'll say before I leave, I watch your show like every single day. Like this is my show. So like I really appreciate everything you do.
Well,
I get disappointed when I look and you haven't uploaded a video. I'm like, oh gosh.
Well,
what am I
thank
gonna
you.
watch today?
Well, thank you. We try to do a video every day, even if we go on vacation, unless I'm flying, something along those lines. And that's why I try to do it every day, is because I do know people have called and said, oh my gosh, is Scott okay? He hasn't done a video in a couple of days. Is he sick or something? No, he's in trial.
Right.
So I do that because people expect
he has a 9 to 5, yeah.
Yep. All right. Well, thanks for the call. Great call. Good luck in school. And if you got any more questions, give us a call. All right.
Okay. Thank you so much.
All right. Thank you. Well, ladies and gentlemen, can you believe that it has already been 2 hours? Goes by the fastest 2 hours in the world. My God, that went by fast. 2 hours. All right, ladies and gentlemen, that's all we have for you for tonight. I appreciate you taking the time to join us. I really do. I know there's lots of other things that you could be doing, but the fact that you took the time to join in and watch me does not go unnoticed, and it is definitely appreciated. So thank you. Thank you very much. So have a wonderful night. Thanks for watching, and you know the drill. Subscribe if you haven't, like if you do, leave me a comment below, and hit that little bell for notifications. And remember, check us out on any of your favorite podcasting apps. And always remember and never forget, the Constitution